Hello, I'm Professor Rich, and this is TYT History. If you missed my first video, it's called Why Iran Doesn't Like Us. Check it out. Those of you who watched it, I appreciate it. I love the comments. My two favorite were, to a bug, your head must look like their sun, and I will transmit this information to Vladimir. So what I try to do here is I try to give some historical context to whatever issues are kind of going on in the media today. And a lot of people who saw the Iran video wanted me to talk more about the Middle East and Iran, and I'm going to do that, but I'm not going to do it today. I do want to do some future videos on some issues like Nasser and Arab nationalism, the origins of Al-Qaeda, and Iraq. But those are going to have to be down the road. Today what I want to talk about is judicial activism. Now I'm sure I'm going to get some minor details wrong. They don't pay me to do this, so I don't really take the time to research it. I just kind of start talking. And I look forward to seeing in the comments what you guys have to add. Now, judicial activism is in the news these days because, of course, the court is considering the what they're calling the ObamaCare case. But I want to go back and look at judicial activism, and I kind of want to look and see how it turned out. When the court decides to get involved in the big political issues of the day. Now, the most activist judge of all time is probably John Marshall, who's one of the early Chief Justices of the Supreme Court, and I'll probably do a whole show on him later. But today I want to talk about the 1857 Dred Scott decision, the Supreme Court of the 1930s that fought with FDR over the New Deal, and the Warren Court, and then a little bit into the Burger Court of the 50s, 60s, and 70s, who pushed so much of our civil rights legislation and our rights of the accused legislation. Now, in 1857, the Supreme Court decided to get itself directly involved into the big issue of the day, which was slavery. Slavery was such a contentious issue that obviously there was violence in Kansas, people killing each other almost on a daily basis there. And the Congress had issued a gag order. They wouldn't even discuss slavery because the fighting over it was so intense. And into this comes the Dred Scott case. Now, Dred Scott was a slave who lived in Missouri with his master, and he was taken to Wisconsin, which was a free state. And in Wisconsin, they returned back home to Missouri from Wisconsin, and then years later the master died. And Dred Scott would argue when the master died that he was free because he had entered a free state. And by entering a free state, he became a free man. Well, the Supreme Court took up this case. It's called the Taney Court because the Chief Justice was Roger Taney, a man who, curiously enough, freed his own slaves, would make the following ruling. He starts out by saying that black people are not citizens. Therefore, Dred Scott has no legal right to bring a case at all. And so he begins by throwing the whole case out. But then he gets a little weird because he proceeds then to rule on the merits of the case even though there is no case. He strikes down a big law, the Missouri Compromise, which had said that slavery could exist in a certain part of the country but not another part of the country, which is why this is an activist case. Specifically what he says is that no state or the federal government can deny people of property, which would mean, in his interpretation, that no state could ban slavery. And so in 1857, Roger Taney in this case turns every state in the country into a slave state. This is a really big ruling on a really high-profile issue. Well, let's look at the impact of this. What it does is it creates a huge backlash against slavery. It was already contentious, but many northern states and many northerners who maybe had not had real strong feelings about the issue are going to become very energized by Taney's ruling. A lot of people felt, well, slavery can stay where it is as long as it doesn't go anywhere else. But declaring at the same time that black people aren't citizens and that no state can ban slavery is actually going to be a major stepping stone on the way to the Civil War. And so here we have a case where the Supreme Court gets involved in a really, really contentious issue, and it creates a giant backlash, a backlash so big we're going to end up with 3 extra amendments to the Constitution, the 13th, 14th, and 15th Amendments, specifically designed to get around the Taney decision. Now, the next thing I want to talk about is the New Deal Court. FDR, when he takes office in 1932, begins passing a lot of legislation creating new government agencies, new roles for government, and new regulation of business. And a very pro-business conservative Supreme Court, similar to the one we have today, begins knocking down FDR's programs. Well, FDR gets angry and he begins blaming the Supreme Court for preventing the recovery from happening. And he goes so far as to propose a scheme where once the justices reach a certain age, he's going to appoint an assistant justice, a justice to help them, because they're old. And this would change the number of justices on the Supreme Court from 9 to, I want to say it was 15. Well, the number of Supreme Court justices is not set by the Constitution. And in fact, it had changed reasonably frequently from 1789 when the Constitution was written until Grant's administration in the 1870s. But it had been stable at 9, I guess, by this time for almost 70 years. And most Americans had accepted 9 as the number, so there was a great pushback against FDR's attempt to pack the court. And that's what everybody remembers, but what people might not remember is the court caved. There was so much political pressure generated by their fight with FDR that the court gave up. One of the justices who had been voting against FDR consistently flipped and started voting in favor of FDR consistently. So we remember the failure of the court packing scheme, but we should probably also remember that FDR got his way. And once again, the court, trying to stop the New Deal, created a lot of pressure on the backside, and FDR ends up getting his way. Now the third court that I want to talk about, we call the Warren Court, because Warren was the Chief Justice. Warren, interestingly enough, was appointed by a Republican. And in 1954, they're going to make the Brown versus Board of Education decision. Now, I do want to say that one of FDR's great legacies, we think about the New Deal, we think about him leading us through World War II, but we should also remember that this great civil rights court of the 50s and 60s was filled with FDR and then later Truman appointees. And so we also have to give FDR a considerable amount of credit for the civil rights victories of the 50s and 60s. Now, of course, the Brown versus Board of Education case desegregates public schooling. But they're not going to stop there. I got to look at my notes. In 1961, the Supreme Court is going to rule that evidence obtained illegally, meaning in violation of the Fourth Amendment, cannot be used in court. That's going to then be teamed up with the 1963 Gideon v. Wainwright decision, a case where the man accused of a crime is not allowed to have a lawyer and can't afford one. And he will actually go to jail and put together his own argument that he should have been given a lawyer. It's called a pauper's petition. He does it all on his own. And the Supreme Court agrees with him, and they say that the court will appoint you a lawyer. You know that because of the next case, the 1966 Miranda v. Arizona case, where a man accused of a crime or picked up for a crime is not informed of his right to remain silent, and a confession is beat out of him. And from the Miranda case, we get the idea that the cops can't question you without your lawyer present, and they have to inform you of that right. So we get and everybody knows this from crime shows, hopefully you don't know it from your own personal experience, but you have the right to remain silent. Anything you say can and will be held against you. And you have the right to an attorney, going back to the Gideon case. Finally, in terms of rights of the accused, in 1972, and this is now the Burger Court, and this is actually a dominant Republican court, is going to rule that the death penalty is unconstitutional. Not unconstitutional in certain states, not unconstitutional in certain circumstances, just flat out unconstitutional. Now this will be overturned fairly quickly, but it goes to show you how far the Republican Party has gone when a Republican-dominated court made the death penalty illegal. These cases all deal with rights of the accused, and they are going to get kind of bundled up with Brown versus Board of Education and another really important case, a 1971 case called Swan v. Mecklenburg County, where the Supreme Court is going to allow busing to integrate schools to get black kids and white kids in the same schools. These cases will create a massive conservative backlash. In fact, I would argue they will create the foundation of the modern conservative movement, which begins as an anti-civil rights, anti-desegregation movement, coupled with this, what they called law and order back in the day. Of course, remember, to many people, when they thought of criminal, they thought of minorities. So these movements may seem like two separate things, but I think in a lot of ways they're really the same thing. Now, the final case, and again, this is the Burger Court in 1973, is going to be Roe v. Wade, where the Supreme Court is going to move into abortion. And this is possibly the most activist case in the history of the Supreme Court, where the Supreme Court is literally going to legislate from the bench, where they're going to write a very complicated, what amounts to a law, creating the concept of trimesters. Trimesters are not a medical invention, they're a legal invention created by the Supreme Court in Roe v. Wade. Now, think about this. We're talking about law and order, we're talking about civil rights, and we're talking about abortion. Now, how much of that is at the heart of the modern conservative movement? It was all created as a backlash against the Supreme Court decisions, against Supreme Court activism. If you went to the South in the 1950s and 60s, they would burn Earl Warren, the Chief Justice, in effigy. There were impeach Warren signs throughout the South and wanted posters, wanted dead or alive posters featuring Earl Warren. And so when the my point is, when the Supreme Court gets involved in these things, they create a lot of pushback. Now, of course, we're talking about today, with particularly the Bush v. Gore decision in 2000, the Citizens United decision allowing corporate money into elections at unprecedented levels, and potentially now the ObamaCare decision. And I'm just wondering, are they creating their own pushback? Are they creating the kind of blowback that we saw with the Dred Scott case, the anti-New Deal legislation, and the civil rights and rights of the accused legislation of the 50s and 60s and 70s? It is easier to organize people to be against something than for something. If you talked about civil rights in the 1960s, abortion in the 1960s, you were probably talking to a women's rights activist who was telling you that because abortions were illegal, women were having to get abortions on kitchen tables and in bathrooms using coat hangers. After Roe v. Wade in 1973, if people were talking about abortion, it tended to be a religious person who was devoutly against abortion. My point being that once you make something illegal, it becomes much easier to go after it. Now, here's my final question. Let's say the court does throw out Obamacare. And, of course, one of the things that would mean is that the pre-existing conditions wouldn't be covered, and you couldn't put your kids on the insurance up to the higher age limit. Well, the insurance companies are going to stop doing that immediately. So that would be in June. The court case would go, the court ruling would go into effect immediately. And in June, people would begin receiving letters. And we're going to see, 30-something mothers with 3 kids who have to get chemotherapy dropped off the insurance right away, because the insurance does not want to cover them. It's expensive. And we're going to see a lot of people in their 40s and 50s seeing their 23-year-old college student kid be thrown off their insurance. And how are they going to react? Are we going to see those stories on the news? You think those people are going to show up on the Young Turks, Rachel Maddow, the Today Show? And so I'm just wondering if these people really know what they're doing when they decide to put themselves front and center into the biggest political issues of the day. Because I would argue that it hasn't really worked out that well for the Supreme Courts who've chosen to do that in the past. Thanks for listening.